And Christian groups are celebrating what they see as a major win for religious freedom today. The Supreme Court rules churches have the same rights as other groups to seek state money for new playground surfaces or other non-religious needs. Jason Calvi was inside the courtroom as the decision was revealed today. Good evening, Jason.
Good evening, Lauren. In a 7-2 vote, the justices sided with Trinity Lutheran Church of Columbia, Missouri. The church applied for a grant back in 2012 to put a soft surface on its preschool playground. The state rejected its application because the Missouri Constitution bans state money from going to any church or religious group.
Writing the opinion for the majority, Chief Justice John Roberts says the state violated the First Amendment. That's because it denied a public benefit to an otherwise eligible recipient solely on account of its religious status. He writes, in this case, there is no dispute that Trinity Lutheran is put to the choice between being a church and receiving a government benefit. The rule is simple. No churches need apply. In dissent, Justice Sonia Sotomayor says the ruling weakens the nation's long-standing commitment to separation of church and state. She writes, the court today profoundly changes that relationship by holding, for the first time, that the Constitution requires the government to provide public funds directly to a church. Frank Scatoro, a Catholic lawyer inside the courtroom today, says that line of thinking is troubling. He says the majority got it right.
It's an extension of the principle that you cannot deny fire and police protection to an entity just because it's a church. Imagine a church is on fire. Is the fire department going to say, would it even be permitted to say, well, we're not going to put out this fire because the entity that is in flames is a religious institution? Well, no.
The Catholic League says this case tackles the Blaine Amendment, a provision in 38 state constitutions. That amendment bans state funds from going to private religious schools. The group, Catholic League, says it's part of historic anti-Catholic bias in the United States. Lauren?
Jason, Education Secretary Betsy DeVos is praising this decision. Tell us what her take is on it.
She's a longtime supporter of school vouchers, and she says this ruling shows that programs designed to help students will no longer be discriminated against just because of their religious affiliation. And this is a similar sentiment we saw in a just released statement from the U.S. Bishops' Conference. They're praising the decision, calling it landmark. Lauren?
Correspondent Jason Calvi outside the Supreme Court. Thank you, Jason. The law firm representing Trinity Lutheran Church describes the Supreme Court's decision as an important precedent to protect religious freedom. Joining us now is Michael Farris, President and CEO of Alliance Defending Freedom, a nonprofit legal organization advocating for the rights of people to freely live out their faith. Welcome to the program.
It's my pleasure to be here.
What a big day for you, huh?
It's a great day. The Supreme Court held that religious equality is the right of every American citizen, including religious people.
Well, we heard from our reporter Jason Calvi about the nuts and bolts of this case, the Trinity Lutheran case. What does it mean for the country?
Well, it reaffirms a broad principle in a newer and broader context. And that principle is this: religious people are not second-class citizens. If the government decides to open up a general program and wants to keep religious people or religious groups out, that's an unconstitutional denial of the free exercise of religion. There's an equality component in the free exercise clause that was importantly affirmed and to some degree expanded today.
Well, there were some dissenters in this. Justice Sonia Sotomayor didn't like it. She said it weakens the country's commitment to separation of church and state. And Ruth Bader Ginsburg says that it profoundly changes the relationship between the two. Is that true?
No, it's not true. The Supreme Court ruled in a separate case a couple of decades ago. I happen to have argued that older case 9-0 that it does not violate the Establishment Clause, the so-called separation of church and states, to include religious people or religious institutions in government programs. That was the Witters case. And they are simply trying to rail against a long-standing majority, a unanimous majority opinion of the Supreme Court. Their views are really an extreme minority. I think they're outliers. The mainstream decision here is the 7 votes that we saw.
Well, the justices also said that they are going to hear Masterpiece Cake Shop versus Colorado Civil Rights Commission. Right. And you represent the owner of Masterpiece. Yes. So Jack Phillips, who declined to design and bake a cake because he said that the same-sex wedding violated his religious beliefs. That was in 2012. What is at stake in that case?
Well, this is probably the pivotal case on the whole issue of the clash between same-sex marriage and the right of religious dissenters. We have another case in the pipeline involving a florist. In both of these cases, the issue is not whether or not they will serve gay people. They always have served gay people. The question is, can they be forced to create a creative message through culinary arts or floral arts or other arts that require them to endorse the same-sex wedding? That's the difference. In the Obergefell decision, Justice Kennedy say, we're not going to trample on religious people. Well, this case will decide whether that's true or not.
And we will find that out later next year.
That's right.
All right. Thank you so much for joining us, Michael Farris, President and CEO of Alliance Defending Freedom.
Thank you very much.